Good morning, good afternoon, good evening. It's Patriot Smoothie here to summarize day 28 of the trial of Tamara Lich and Chris Barber. It was a busy, heavy legal day, so make sure to stay tuned to the end. There is some big developments as per usual. Stuff is finally happening, folks, and things are going places. Where those places are, we'll find out together. But the good news is that the defense has finally started. It is now their turn. It was day one of the defense's case today, Monday, November 27th, and they did a really good job. Now, a lot of people who are watching it, and again, sorry guys, I can't be in the courtroom right now. I'm dealing with a lot of other things in my personal life. Maybe one day I'll talk about them, but unfortunately I can't be there. But there are some really good people in there who are bringing this excellent coverage, and I'll be sure to continue linking to them on my social media accounts so you can follow along with their courtroom reporting, and I'll continue to produce these summary videos for you. Again, stay tuned to the end. Like the video, it really helps. Subscribe to the channel, it really helps me. Leave a comment down below letting me know what you think about all this. But yes, like I said, it was the defense's case today, day one of their case after 27 days of the Crown, and we're off to the races, folks. The defense said that they're bringing two applications, and the second application, the Crown doesn't know the nature of it. The Crown actually made an appeal to the judge today to have her order the defense to tell them what it is, and the judge, Justice Heather Perkins McVeigh, basically told the Crown that she's not going to order the defense to display their case publicly in court to them, that they could talk to them out of court if they want and see where those things go, but she's not going to order them, the defense, to just expose their case. But they did bring their first application, and their first application, I was correct, it's a directed verdict. I got it a little bit wrong, but I'll clarify. So what it is it's a directed verdict motion, basically, because that's the standard for this. The defense is making an application to dismiss the Carter application from the Crown, where evidence against one, Chris Barber, applies against the other, Tamara Lich. The defense counsel, Eric Granger, for Tamara Lich, basically made his heavy legal submissions today, and he argued that the Crown has called 16 witnesses. Not a single one of those witnesses, according to Mr. Granger, has had contact with Tamara Lich, and that they simply failed to make the case, that the evidence doesn't support the Carter application, and that the evidence for dismissing the Carter application is a directed verdict standard. But they say it's less in this case because the evidence is so circumstantial and light, and all the other legal arguments. Now, a lot of people who are watching the coverage today may be like, well, this is really boring, I don't like this. Eric Granger and Lawrence Greenspan are an amazing duo. One of them, I find, my observation is that Mr. Granger comes in with the legal foundations, which is necessary. You can't have an argument in court, as I understand, without legal framework. You can't have it without citing your case law and having good reasons for why the things you're saying are true and legal and the correct decision for the justice and judge to make. So, in my opinion, Eric Granger comes in, he lays the foundation of the legal framework of the case law, and he cited quite a bit of things, R.V. Singh, R.V. Khan, and concerning the Carter application and the dismissal of that standard, and a lot of other ones that I can't remember because it was heavy, and that's his job, and he's really good at it. He does that, and then Mr. Greenspan comes in and he ties a bow on it. And that's just been my observation. I could be totally wrong. That's just how I find they've played out throughout this. So anyone who watched the proceedings today and thought they were a little bit dry or boring, understand it's 100% necessary, that it was a masterclass in how to do these things. Trust me, I read all of it, and I talked to people in the know about how legal proceedings work, and they're very impressed. It was very good. So the first application to dismiss the Carter application from the defense. The second application from the defense, we don't know what it is. It could be anything. Who knows? Certainly the Crown isn't being given insight onto that, and why should the defense have to spoil their case? It makes no sense. So I'm glad that that's being upheld. So it's interesting because there's three phases to the Carter test. Basically, that a conspiracy, a common unlawful design exists, that there's direct evidence. You can call whatever they have against Chris Barber direct evidence, where he's telling people to be peaceful and go shake officers' hands and this and that. You could call that direct evidence if you want. And then that there's any direct declarations against are then receivable against the party. So I guess that means that the vice versa effect, where one against the other and so on. Now, in his submissions, Mr. Granger expanded to say that it's not just that there actually has to be a concept of agency between the parties, that there has to be an agreement, and that there has to be that common unlawful design, that they have to have a conspiracy to engage in an inherently unlawful act. And he argued that coming and trying to end restrictions is not an inherently unlawful act. And then he brought up other different things to support that, like the Justice McLean decision for the February 7th Horn injunction, and so on and so forth, that said that the protesters were at liberty to continue a peaceful, lawful protest, so long as they abided by the conditions of not honking the horns. And as it's been brought up previously in the trial, there was no other conditions attached to that. There was nothing about the idling of truck fumes and all these things from the different litigants and applicants in those motions. So, you know, they've talked a lot about them in their so-called, you know, the evidence of these 16 witnesses, but there was never in their motion to stop. It was just the horns, and that's been explored by the defense team as well. Why wasn't that in there? Anyways, Justice McLean said, yeah, liberty to proceed in a legal, lawful protest so long as you abide by the terms of the honking order here. And that's what happened. And all these witnesses, Crown witnesses, also testified that afterwards the so-called never-ending honking became more rare. It was more spontaneous, less consistent, which was a big contradiction during their testimony, where they originally maintained that it never ended. So that's really interesting, that there's the three steps, that there has to be the agency concept between the accused. As I understand, now these are very heavy legal concepts, so I'm going to make a mistake. This is just my opinion. I followed this thing for the vast majority of the thing. I've been in the courtroom for all but 2 days. Unfortunately, I don't see myself returning to the courtroom anytime soon due to other commitments, but I will do my best to continue summarizing, as I said, and there's some really good people in there. And it, you know, there has to be this evidence that a declaration has been made in furtherance of the conspiracy of an actual illegal action, intention. There has to be that unlawful intention in their conspiracy. It's the agreement. So there has to be an agreement, the concept of agency between the two co-accused, where they're not just doing something together, that they're agreeing to do it together. It's not just happening by happenstance. They're in solid agreement to do it together, and what they're intending to do is inherently unlawful, which protesting restrictions is not inherently unlawful. And Mr. Granger gave examples of things that would be inherently unlawful, like weapon, violent crime, or proceed drug crime, whatever. And that's a really interesting point. And of course, that the evidence on itself fails on the surface. And he said that there's too many gaps in the evidence, in evidentiary gaps in this case, that the Crown has presented. They took their best shot and they failed. They failed to prove that there was an agreement between Miss Lich and Mr. Barber, that what they were trying to do was a common unlawful design to come to Ottawa protesting restrictions, which is not inherently unlawful. So they've failed the Carter application on its surface. And also the evidence presented has huge evidentiary gaps, and that Mr. Granger maintained that the court would have to speculate to bridge that gap, because the inferences of unlawful intentions and the evidentiary gaps themselves is too great. It's too wide of a gap, and there would be speculation, which is just not. It's not reasonable. It's not a proceeding that cannot go that way. So the case law, and like I said, so it would be required. The speculation would be required to fill those gaps, and that's not a good decision. And I don't think that the court will do that, honestly. And that so we talked about how there has to be the common unlawful design, the inherent illegality in what is conspired to do, the concept of agency and solid agreement between the two, where they're not just doing the thing, that they were agreeing to do the thing. It's not just happening by happenstance. Okay, two people together in a room committing a crime together by accident, I guess you could say. Well, no, they went there with the actual intention to break the law. There was that conspiracy to break the law. They were in an agreement to break the law, and that's required for this Carter application, where evidence against the one applies against the other, and that the standard dismissal of the Carter application is a directed verdict. And in this case, I don't think that would immediately acquit Miss Lich. I think it would effectively acquit her. I don't know what as Mr. Granger indicated, there were 16 witnesses called. The Crown took their best shot to prove this Carter application, and none of the 16 witnesses claimed to have anything to do with Miss Lich. So what's left after that? I think Mr. Granger said that there's 4 videos in total of Miss Lich on the streets of Ottawa. There's nothing there. So if this Carter application is dismissed by way of directed verdict under a limited test, mind you, as Mr. Granger said it should be, due to the circumstances of this trial, that there would be no evidence left. That's what we can assume. There would be literally nothing left on the table for the Crown to use against Miss Lich. So she would be, in essence, in my opinion, effectively acquitted, because what's the Crown working with at that point? And not to say that the evidence against Mr. Barber is any better. It's really not. Again, it's meandering. It's weak. There's some major contradictions in the Crown's witnesses. There is missing evidence in the phone of the arguable key Crown witness, Officer Botch. So there's a lot of questions here. And if this directed verdict against the Carter application goes through, and the Carter application is dismissed, and so is the co-conspirators, the co-accused, the evidence against one against the other, there's nothing against Miss Lich that's been entered in this trial, and I don't believe that the Crown has closed their case. So I don't think they'd be able to be like, okay, hold on, guys, we've got this other stuff against Miss Lich we'd like to put in now. I don't think it would work like that. I think it would be they'd have to go with what's there, and there's nothing. Even for Mr. Barber, there's nothing. It's really... And I know I'm racing over some of these legal concepts and high-level things, but I'm trying to summarize it in a way that I understand, and hopefully you can understand too and appreciate that. Again, as always, let me know what you're thinking down in the comments. Like the video, subscribe, it helps. I'm going to keep doing this the best that I can with what I'm working with. And there was also, I forgot to mention, back on day 27, Officer Nicole Botch was talking about the mission statement of the Ottawa Police in late January and early February. I just wanted to bring this up real quick, where she said it was the mission that she was briefed on, but from the Ottawa Police, to support peaceful, lawful protest in Ottawa as of late January, early February, and to keep order and peace downtown. And that was repeated several times, but as is a theme, she doesn't remember who said that. And to be fair, I don't remember stuff from 2 years ago. That's a long time, but you'd think police officers would take really good notes, whether that's in the Signal Chat application or where they belong in the duty book notes. My apologies there. My phone just broke and I had to restart, but it's okay. All is not lost. Let's put a bow on this. So basically, Granger mentioned that the trucks and protesters were brought into the city by the police. They showed them where to park, how to get there, and Granger maintained that there's no evidence where inference can be drawn on any other conclusion that Miss Lich intended to protest peacefully, and that, of course, there's huge gaps in the evidence, and that speculation would be required to make any other inference, which of course would be improper. It would not be correct to do that. So that's where we're at with things, and I think I'm missing one thing. What I want to say is that there was also brought up a comment from Miss Lich during the press conference where she said, she was asked, are you going to go to jail? Are you willing to go to jail if you're arbitrarily arrested? And she said, this is my hill. And Granger added, assuring the court that, or mentioning to the court for its record, that going to jail for willingness to go to jail for an arbitrary arrest is not an inference of criminal intention. If you're going to get arrested arbitrarily and you're willing to do that for something that you truly believe in, that's not an inference. An inference cannot be made based on that you have a criminal intention, a mens rea to break the law because you're willing to go to jail arbitrarily. It means that you're of conviction and you're willing to stand up against undue and unfair persecution and prosecution, that's what I draw from that anyways. And again, the evidence gap is just too big, requires too much speculation, and no inferences can be made towards criminality. There's no evidence of the agreement between the co-conspirators, which dismisses the Carter application on the face. There's no evidence of criminality in the common non-lawful design to go and protest in Ottawa, nor anything they did, including through the Justice McLean decision and the subsequent decision to refresh the order after the expiry. I believe it was 10 days later, where the terms were identical. Again, nothing about the fumes, nothing about whatever other complaints were brought up in court, which is very interesting. And I think the last comment of the day was very interesting, because you may recall, or you may assume, that the majority, in my opinion, most of this case rests on the phrase "hold the line." There was a lot of emphasis put on that during the Crown's statements. Tamara has said it a few times. When she got arrested, someone said it to her, and she said it back to them in reply. It wasn't some like war chant, a la Braveheart, where she was like, "Hold the line." It wasn't like that. And then the defense even introduced videos from Calgary police, I think it was, in Ottawa during the clearing operation, where they kept saying to themselves, "Hold the line." What does hold the line mean? And Justice Heather Perkins McVeigh had a really insightful comment. Again, one of those rare glimpses into how she's thinking about things, and probably wise not to read too much into this, but still a peek at wisdom, where there was mentions of that where there's a lot of interpretations of that. Mr. Granger said there's a lot of possible interpretations, and Perkins McVeigh said that it could mean a lot of things, like stay true to your convictions and to your conscience. And that's all you need to say. That's all you need to know, is because if she's thinking, it doesn't, we don't know what that phrase means, and so much of the Crown's case rests on hold the line of all the things. And especially right now, looking at what's happening around the country and some of the protests and how they're being handled and the things that are being said there. Looking back at the Freedom Convoy, where people were getting fed, there was a lot of community safety. Certainly, even according to the Ottawa statistics, crime went down. It's really hard to try and prosecute these two accused when we could look at everything happening around the country and the world and see that that was actually a very well-behaved protest. That's all for day 28 of this ongoing, never-ending trial. I'll be back tomorrow with another video. Thank you very much from Ottawa and Patriot Smoothie one more time. Get down in the comments. Let me know what you think. Drop a like, drop a subscription. Subscribe to the channel. Really helps. See you next time.